Good afternoon, everyone. I'm Patricia Riley, the chair of Martha Kalina's Labor and Employment Group, and thank you very much for attending this webinar today. With me is Sal Gangemi, a partner in our Labor and Employment Group in the Stamford office. We're so happy to have the group that we have participating. We have HR professionals from a vast range of industries. All callers are in listen-only mode. If you have any questions during the presentation, you can write them in the questions box of your webinar toolbar, and we will review them and discuss them at the end of the presentation. All of today's participants will receive an email from Ms. Michelle Ketchum on Monday with the PowerPoint presentation and an attendance certificate. So let's begin. The event that prompted our deciding to do this, of course, is the recent increase in the salary basis test for employees under the FLSA. So we thought it would be a very timely seminar to discuss that and to discuss generally the proper classification of employees under wage and hour laws. And what we really want to focus on is that the federal law is one thing, but the states that you all work in have, in some cases, different requirements. And we want to ensure that you're aware of all of these nuances. So, with regard to the federal law, the Fair Labor Standards Act requires employers to pay covered employees minimum wage and overtime compensation unless they are exempt. So the exemption is considered to be the exception. Now, the Fair Labor Standards Act has more broad exemptions than even Connecticut and New York would have, and Massachusetts. So these are the exemptions under the federal law. The executive exemption, we have that in all three states that we're dealing with today. And the states that we're addressing are New York, Connecticut, and Massachusetts. The administrative exemption, that is the same in all three states. Professional exemption, the same in all three states. Computer professional exemption is not available in Connecticut, and it is not available in New York. The outside sales exemption is available. The highly compensated employee exemption is not available in New York or Connecticut. The employee would have to meet the requirements of one of the other exemptions. Now, just a little more discussion on the computer professional exemption. I've gotten this question many times over the course of my career, and what we say is, the computer professional, just by virtue of being in that job, is not exempt under Connecticut law, for example, as that person would be under federal law. But often, the computer professional employee is an administrative employee who may fall under the administrative exemption. In some cases, if the person is highly sophisticated, it might fall under the professional exemption. If the person runs a department, it might fall under the executive exemption. So certainly with regard to the professional exemption, rather the computer exemption, often you can find that that person will fit under a different one of the exemptions that is allowed under our state law. And with regard to highly compensated employee, any person that is highly compensated in Connecticut, New York, would still have to meet that state and the federal salary basis requirements. Okay. So keeping in mind that there is a compensation, salary, and a duties test. So the salary basis test is what you would look at first. There are some exemptions and exceptions to the salary basis test, but generally speaking, you first have to look at the salary. Is the person making sufficient money so that they can fall into one of these allowed exemptions? With regard to the professional exemption, that person, and they have to be paid on a salary basis. So the whole thing about the salary basis test is they have to be paid on the salary basis, the minimum salary threshold. And so that means they have to be paid the same amount every week. They have to be paid the same minimum amount every week. And as we'll discuss further on, the minimum amount has changed. But there can be no deductions from the salary except for some very limited exceptions such as intermittent FMLA, that type of thing. But generally speaking, the first barrier for somebody to be exempt is they must meet the salary basis test. Now, I know some of you on the call work for schools, and I have a lot of school and university clients, and I know there are a lot of healthcare institutions on the call. And I want to say that with regard to the professional exemption, teachers, lawyers, and doctors do not have to be paid on a salary basis in Connecticut. They can be paid, and under the federal law as well, they can be paid an hourly basis and still meet the professional exemption, okay? Teachers, lawyers, and doctors. And by the way, no, that does not mean APRNs or CRNAs or any other type of medical professional. The statute limits it to doctors. So this is the event that triggered our wanting to give this seminar. The salary basis test requires that an exempt employee be paid both on a salary or fee basis at a rate at least equal to the standard salary level of, as of January 1st, 2020, $684 a week. $684 a week, that's the magic number. Divide by 52 weeks, and you get a little over $35,000, I think. But it has to be that minimum threshold, $684 a week. So what's interesting about this is you need to start looking at all of your employee salaries now. In Connecticut used to be higher than the federal law. So $455 a week was the federal law. Connecticut was $470 something a week. Now even Connecticut has been superseded by federal law. And because Connecticut is such an aggressive state, a progressive state on behalf of employees, it was the case that basically you had to look at Connecticut law in Connecticut and you'd be covered. Now that's not the case. You must, at a minimum, look at this salary level threshold. If your people are not making this, then they cannot be exempt, okay? Except if they're a teacher, a doctor, or a lawyer, but we're not going to get into that basis. Basically, all of the people that we're talking about here. So if you need to do an audit, an internal audit, start with the salary.
Okay. Well, happy Friday, everyone. This is Sal Gangemi. I'm going to jump in just so that Tricia can catch her breath. So in terms of the salary basis test, what's interesting is that this 455, this increase rather, to the federal increase of the salary threshold was the first increase since 2003. That was the last time it was done. So in many cases, most white-collar exempt employees were likely getting paid more than the minimum at that time. But now that it's increased, you really do need to examine to make sure that you're keeping up with the new requirements. So what does it mean to be paid on a salary basis? Basically, it means that the employee is going to receive each pay period, whether it's weekly or less frequent, on a less frequent basis, a set amount that constitutes all of their compensation. Okay, under the salary basis test, the amount that they're paid can't be subject to reduction because of the quality or quantity of the work that they're performing. Remember, unlike an hourly employee, you're not necessarily measuring the employee's production in terms of the quantity of hours they're working. You're measuring it in terms of the end result. And so that amount, that salary, can't be reduced. If it is, or if there are impermissible deductions taken from the salary for whatever reason, a reason that's not approved by the law and the regulations, then you risk losing that exemption. Okay, so what are permissible deductions? Well, obviously payroll taxes are certainly permissible deductions. You wouldn't expect the government not to include that one. And also full day absences for personal reasons. Okay, let's stop there for a second. So you can make deductions for full day absences for personal reasons, unless it's sickness or disability, including vacation. And when you're dealing with sickness or disability, as long as you have a bona fide plan that provides coverage, like a PTO plan that provides compensation for employees who are out due to sickness or disability, then certainly, as long as they're getting paid through that plan, there aren't any issues. Now, the next thing I want to talk about is the New York threshold for those of you who have employees in New York. New York is particularly confusing, and simply because up until 2021, December 31st, 2021, New York makes this distinction between, first of all, large employers in New York City versus small employers, Long Island and Westchester, okay, and the remainder of New York State. Okay, so if you have employees in New York City, beginning on 12/31, well, actually, let's see, I'm sorry. Oh, so it's currently for large employers in New York City, it's $1,125 a week, and that's pretty much capped out. That's not going to increase anymore. Eventually, it'll be $1,125 a week by the end of 2021, except for possibly the remainder of New York State, which hasn't been determined yet. So again, even though the federal government has raised the minimum salary threshold to $684, it's not going to have any effect on New Yorkers, because in New York, employees already need to be making over $1,125, which is over $52,000 a year. Now, this New York, the way New York has set up its salary threshold is similar to what the Obama administration had proposed when it proposed increasing the salary threshold to approximately, I think it was something like $49,000 a year. And this was supposed to take effect in December of 2016. A court issued an injunction to prevent that from taking place, but in the meantime, while everyone was focusing on that, including New Yorkers, New York kind of snuck in and basically provided the similar exemption. The similar minimum salary threshold. So that's the story in New York. Now, Massachusetts, a few months ago, Massachusetts issued regulations increasing the minimum salary threshold to $6.79 an hour. So it's like $5, $6.79 a week, $5 a week less than the federal. Nevertheless, they're going to have to start paying $684 in order to comply with the Fair Labor Standards Act, and as well as their own law. So we also have something new. Okay, this 10% rule. All right. So before we were talking about how the salary that's paid on a weekly basis needs to be a set predetermined salary. Okay. However, the regulations for the first time have permitted employers to use non-discretionary payments that are made throughout the year, 10% of those non-discretionary payments to make up any shortfall in the weekly salaries. This does not apply to Massachusetts, okay, and it doesn't apply to New York. But it may, we're not 100% sure, but we think it's going to apply to Connecticut because Connecticut law has the lower $455 an hour a week. We should all be so lucky, right? $455 a week salary threshold. And although in Connecticut, you won't be able to take a 10% credit on that $455 a week. Once that amount is guaranteed, anything above that, up to $684, you will be able to utilize the 10% credit. And the reason I say we think this is the case, no one has said anything, but based on our review of how this is supposed to work, it seems very likely that Connecticut employers will be able to use the 10% rule for payments to satisfy the salary minimum after the first $455. That's $475 there.
It is $475 in Connecticut.
Oh, okay. I don't know why I had it $475.
Yeah, $475.
Okay. So after the first $475 is satisfied, then you can certainly satisfy it with 10% of non-discretionary income, including commissions.
Okay, so this is the fee basis. I don't like it, use it, advise that you use it. Most people are getting paid on a salary. This is kind of, in my view, a footnote to the FLSA. This is not even allowed in Connecticut. So I'm sort of going to brush through this because, in Connecticut, you have to do the salary basis test.
That's right.
So.
And also, even under the federal law, executives can't be paid a fee either.
Right. It's very, it's really kind of an esoteric thing,
right.
And it reminds me of something we're not discussing today, another esoteric way of paying people, which is the fluctuating work week.
Oh, yeah.
So call me on that if you have any questions, but we're not talking about that today. And if you do fluctuating work week, that's for non-exempt people anyway. Okay, this you do need to know. So once your employees satisfy the salary basis test, and again, you're going to be looking at, if you haven't already, audit your workforce so that by January 1st, 2020, you are in compliance with the FLSA. And if you're in New York, obviously you're already in compliance with the FLSA because the salary basis is higher. But if you're in Connecticut, you might have been paying exempt employees $475 a week, and that's not going to cut it anymore. So in addition to the salary threshold, you have to ask yourself, are they really performing exempt duties? And my experience is that if somebody's getting paid at the lower end of the exempt salary test, they might not even be exempt because they might not really be doing exempt work anyway. So now you have an opportunity to reclassify employees and to consider whether they're really doing exempt work and how you want to deal with them going forward. If they're at the low end and under the new FLSA minimum, do you want to raise their salary and make them exempt, or is it the case that they really are not exempt, or there's so much on the borderline that we might as well just make them non-exempt and actually pay them a salary that is an hourly basis that's going to reflect what their previous salary was. Okay, so an exempt employee's primary duty must be the exempt work corresponding to a specific particular exemption. Sometimes someone's going to qualify for more than one, but they have to qualify for each one. And so the Department of Labor in the Federal Department of Labor and Connecticut State Department of Labor, they both look at the primary duty. Is the principal or most important duty the employee performs, an exempt duty, and this requires a fact-specific review based on the employee's position and actual job duties. So a footnote here about job descriptions. What I have found when I have done audits and defended employers in audits, both with the U.S. Department of Labor and the Connecticut Department of Labor, is it's very important to have your job descriptions be up to date and to have them truly reflect what the person is doing. So this is, again, part of an HR audit process of, are the job descriptions up to date? Do they reflect what a person is doing? Because sometimes where employers get in trouble is the HR team looks at job description and, in fact, the manager is not having the employee do what's on the description. And the description may be higher level exempt duties, but in fact, they're doing very rote basic duties that would not fall under the exemption. And that's particularly true for the administrative exemption. To me, the administrative exemption is the biggest potential red flag and pitfall and risk category. So if you find when you're doing your audit that you have a lot of people that you've thrown into the administrative exempt category as a kind of catch-all, and they are at the lower end of the salary test, and in fact, under the new federal laws, they wouldn't even make it, so you might have to increase their salary. You need to look really carefully at those people to see if, in fact, they are administrative exempt. So let's start with executive exempt. That's easy. That's an easy one, okay? So you meet the salary basis test, then what are their duties? The executive exemption duties. The primary duty is management of the enterprise where the person is employed, or, so in other words, that's the president of a small company, let's say. Or, this is more common in larger organizations, a customarily recognized department or subdivision of the enterprise, okay? So that means, a department. That doesn't mean Joe has a job where he is in a subdepartment of a subdepartment of a subdepartment of a subdepartment. You really have to say, is this truly a department? And here's the catch. The executive exemption requires that the employee customarily and regularly direct the work of 2 or more full-time employees or their equivalents. So, where you run into trouble here is if you have a small department with an executive who's only managing 2 employees and 1 quits, guess what? Now that person's only managing 1 employee and will not meet the executive exemption because it has to be 2 or more full-time equivalent employees. So if that's 4 part-time employees, 20 hours each, so that the total is 2 40-hour employees, that's okay. But if one of those part-time employees quits, you're now down to only 3, you don't meet the exemption. So this is where, when you have smaller departments or smaller companies, this executive exemption could be risky if the person is not managing more than 2 full-time employees. The employee also has to have the authority to hire or fire other employees, or whose suggestions and recommendations are given particular weight regarding the status of the employees that he's supervising or she's supervising. So it can be with regard to hiring, firing, advancement, promotion, or other change of status.
And I'd like to make a comment on this one. This is one where I've seen a lot of problems, where someone will refer to someone as a manager, but in fact, they really don't have any authority to do anything, to hire or fire. They make recommendations, they'll make suggestions, but at the end of the day, they really have no say. So here it says, their suggestions and recommendations are given particular weight. We didn't just throw those words in there. That's like those words are in the regulation. So at the end of the day, you have to ask yourself, what does it really mean that they're given particular weight? You need to be very, very careful in referring to, obviously, just because you're referring to someone as a manager doesn't necessarily mean they're a manager unless they have some ability to affect the terms and conditions of someone's employment.
That's a great point. So the point is, just because someone has the title of manager does not make them exempt under the executive exemption, and that's the exemption that we're talking about here. Right,
and that's the one you really have to look at closely too. Just make sure. A lot of people think it's easier. Just look, we want to pay salary. We won't have to deal with we can disregard to some extent the duties test, but that's not really the case, obviously. And this here is I've seen this time and again where it's clear that the person does not qualify for the executive exemption despite their title. So
it's a good point.
Thank you.
I'm throwing you over to administration.
Oh, why thank you. Why thank you.
Speaking of misclassification.
Right.
The catch-all.
That's right. So administrative exemption is a real pain in the neck. And I'm going to tell you why I think it's a pain in the neck, Tricia, and you tell me what you think, okay? Mm-hmm. So it talks about, all right, so first of all, the employee's compensation has to satisfy the salary basis test, okay? All right. The duties test, this is I'm going to read this out, okay? So the employee's primary duty is performance of office or non-manual work directly related to the management or general business operations of the employer. Stop right there. I have no problem with that. Okay, that's pretty easy to figure out. It gets complicated when you throw in or the employee's customers, all right? So they're performing office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. this is where you tend to fall into a little bit of a gray area, okay? So, the administrative exemption, for example, would apply to, let's say, the head of HR, someone who directs HR, okay? But what about, it would also apply, presumably, to a person who's performing HR functions for the company's clients. And to me, there's a little bit of a gray area there, because if you're in the business, let's say, of providing these outsourced services to companies, and you're providing that service to the customers, sometimes it's difficult to tell whether or not you're engaged in administrative duties, or you're just, selling the company's products or services. An important aspect of the administrative exemption is the exercise of discretion and independent judgment regarding matters of significance, which also tends to be a gray area as well.
So let me jump in here. To me, this is always where this exemption fails, when people use it as a catch-all. And so to go back to Sal's example, what are some examples of departments that are generally administrative departments because they're performing office or non-manual work directly related to the management of the business, okay? HR, classic example. Finance, classic example. So let's talk about IT is also in, if it's not an IT organization, the IT that's doing the work for the organization, the administrative work for the organization. So we're talking about accounting, budgeting, auditing, insurance, risk management for an organization, quality control for an organization. Now, here's some more: purchasing, procurement, advertising, marketing, research, safety, personnel management. Okay, so all of these kinds of things are generally administrative. There's more. But wait, there's more.
There's more. If you act now,
you too can get in on the administrative exemption at no cost. Okay.
And we'll throw in a professional exemption just for free.
All right. See, who said the FLSA is boring?
That's right.
Okay. Employee benefits, labor relations, public relations, government relations, computers, legal, other similar activities. Okay? Did we make our point?
Yeah, I think everyone gets it now, right?
Everybody get it. But here's the trouble you run into, and I've done this for audits of large-scale organizations and small organizations too. Not everybody in HR is exempt because they work in HR. Not everybody in finance is exempt because they work in finance. They have to be able to exercise discretion and independent judgment regarding matters of significance. And so where I find this gets really gray is in finance. People will say, oh, she's really smart, she's really good. She, gets the bills out on time. She pays invoices. Okay, I say, what kind of invoices? The run-of-the-mill invoices, this, that, and the other thing. Does she have the authority to decide how to spend the company's money without going up, to other people to get? Oh, no. She has a limit of $500. Okay, boom, done. That is not going to be, unless there's some other information that I don't know about, not likely an administrative exempt position. Creating reports. So there are a lot of people whose job is to create reports for the organization, and they're great at Excel, and they're great at whatever kind of reporting system you have, and they can, push the buttons and come up with the best reports. That's kind of a classic example of, in most cases, that is going to be a non-exempt position. Because if you're making reports, and that's all you're doing, but you're just preparing the reports for other people, and they're the ones making the decision, that's non-exempt. So, in HR, obviously the manager of HR, and if your people are making independent judgment and discretion about HR matters, they're the ones that will sign off on a termination. That person likely is an exempt employee because they have the authority to say, over the group that they're the manager for example, or the HR liaison for. If they're the go-to person for a decision that is and exercise of independent discretion and judgment regarding matters of significance. The matters of significance was added a few years ago to clarify that it's really got to be sort of a high-level administrative function. And the other thing that I know the U.S. Department of Labor targets and looks at, and Connecticut as well, is if you have too many people in these administrative departments categorized as administrative exempt, that's going to be a red flag for them, because not everybody in the department is going to be administrative exempt. So you have to look at sort of the balance, who's really doing that kind of work. And of course, the manager of the department, if that person is supervising two or more full-time equivalent employees, that person's going to go under the executive exemption as well. So that's an example of what I'm talking about. Sometimes people fall under more than one exemption. Okay, so we blew through those.
I want to give an example of something that I came across about 10 years ago. This large consulting firm was doing consulting work for its clients, of course, and it hired a bunch of people to sort of do the consulting, to do the consulting work, and essentially they would bill these people out to the client on an hourly basis. But at the end of the day, the only thing these people were doing was data entry, and they were getting paid $95,000 a year. So one might not think, oh, these people should be getting overtime because they're making $95,000 a year, but they weren't satisfying. Their skills did not, or their function didn't satisfy the duties test. But they were billing these people out as if they were, professionals or consultants. But it was the administrative exemption that they were trying to fall within. So that don't get comforted by the fact that you're paying people a high salary.
That's a really, really good point, particularly in our jurisdictions where the highly compensated test is more than $95,000,
right,
but it doesn't even apply. So you could be, if somebody's doing data entry, right, and you're paying them $200,000 a year, but that's all they're doing is data entry, they may not be exempt, and
that's
then
right,
you owe them overtime on them.
That's right.
They're working overtime. I will say, however, that a true executive assistant or a true administrative assistant who's making some kind of important decisions and has a lot of discretion, makes a lot of money, that person may be exempt, but the devil is in the details.
That's right.
It's in the job description, and it's in the reality of what are they doing on a day-to-day basis.
Right, that's right.
So that's another good example where if you have an administrative exempt person, administrative assistant, whose job title has these highfalutin job duties that they're supposed to be doing, and it turns out that really what they're doing is answering telephones, and that's it, that's not an exempt position. So, I think that's really quite what we're talking about here. Okay, you want to go to professional? Yeah,
I'll do the professional. So now we have the professional exemption. And under the professional exemption, generally, you have to satisfy the salary basis test. As Tricia mentioned before, though, if you're a teaching professional or a licensed and practicing lawyer or a physician, you can be paid on an hourly basis without jeopardizing the exemption. Now, within the professional exemption, in terms of duties, you have what's known as the learned professional and the creative professional. Okay, let's go with the learned professional. This is a professional who performs work that requires advanced knowledge. Okay, it's advanced knowledge either in a field of science or learning, and it's customarily acquired by a prolonged course of specialized intellectual instruction. Under these circumstances, under this duties test, I would say, and I think Tricia would agree, because I think we're right, that a 4-year college degree would not suffice to qualify someone as a learned professional under most circumstances.
4-year would.
4-year would.
Okay, yeah. So that's a good point.
Yeah.
Connecticut, the Department of Labor has told me
flat out. Oh, is that right?
4 years required.
Oh, is that
so
right?
In New York,
FLSA,
I know, it's not, the FLSA does not explicitly say 4 years required, nor does the Connecticut regulation say 4 years required. But in conversations I've had with the Connecticut Department of Labor, I have been told that you better have that person have a 4-year degree.
Yeah, right. Yeah, see, that's interesting because in New York, that's not the case. New York talks about postgraduate requirements in order to get to be considered a learned professional. So, see?
And the other point I want to make there, and maybe, well, let's keep going. And then
No, that's okay. Well, then
let's say I'm learned professional since we're on that one.
Yeah, why don't we say
They have to be working in the field in which they have a degree. Right?
That's right.
So if you're a CPA.
And you're waiting tables.
Exactly.
Right.
Or doing data entry.
Right.
You're not a learned professional.
That's right.
If you're a lawyer with a law degree, but you haven't passed the bar, and so you're working as a legal assistant, you're not a legal professional. You're not a professional exempt employee. So it's nice, and this comes up a lot. I don't see any architectural firms, but we have a number of architectural clients I've advised in this. Comes up a lot in the architecture world because there are some people who are highly skilled in design and various areas of architecture, but they don't have the 4-year degree, and so therefore they, at least in Connecticut, are not going to be professional exempt if they don't have that degree. And conversely, if they do have the degree, but they're not doing what's required, they're not using the skills for the degree in their actual job, then they're not going to be professional exempt. But most people are going to be professional exempt. And then, of course, since we do have a lot of healthcare organizations on the phone, I just want to make the point that somebody might qualify for an exemption, but an organization might choose not to pay them as an exempt professional employee for whatever reason and may treat them as a non-exempt. So you can treat anyone as non-exempt and pay them overtime.
You'll never get in trouble for that.
You'll never get in trouble for that.
Right.
So if you have people working 80 hours a week who could apply for the professional exemption, but you're choosing, maybe because of market conditions, maybe in some cases, collective bargaining agreements or whatever the reason, if you are choosing to pay employees on an hourly basis, that's fine. You can make that choice. But you can't go back, and if you do go back, you have to really consider how that's going to play out. And in other words, you can't go back from salary to hourly without there being some real assessment of, do we owe this person back wages? Were they misclassified? So there's two different things here. If you intentionally pay them hourly because you don't want to classify them as exempt in the first place, fine, no problem, as long as you've been consistent in that application and paying them overtime. But with regard to reclassification, which is important to keep in mind now, if you have people that you have been paying on a salary basis and you're looking at this and you're saying, wow, I actually don't think they're really exempt employees, we never paid them overtime, you have to consider when you're reclassifying them, do you owe them overtime and or what are the risks? It can be a big project to reclassify employees if you believe that they do need to be reclassified.
So then we also have the creative professional, okay? And this is someone whose primary duty requires invention, imagination, originality, or some talent. And it's generally in a recognized field of artistic or creative endeavor like music, writing, acting, that sort of thing. So we're talking about artists and musicians and writers. Now we have an exempt teaching professional, which is also covered by the professional exemption, where their primary duty is teaching and lecturing or instructing. But the teacher has to be employed in an educational establishment. So that's what we have there. Now, there's a 3-part test for determining whether someone qualifies for the learned professional test, okay? And essentially, it requires work that is predominantly intellectual, okay? Work that requires the exercise of discretion and judgment. It's not routine, mental, manual, mechanical, or physical work. And it generally involves using advanced knowledge to analyze, interpret, or make deductions from different facts and circumstances, okay? And again, it needs to be in the field of law, medicine, theology, accounting, actuarial computation, engineering, and architecture. Teaching, physical, chemical, and biological sciences, pharmacy, and other occupations that have a recognized professional status. And Yeah, so that's really basically it. The professional exemption is divided into different types, like as we've said, the learned and the creative, and the tests for determining whether the people in those categories satisfy the professional exemption. It varies. It's different, just so that it fits the what we're talking about. So now let's go to the outside sales exemption. Okay, the salary basis test does not apply to the outside sales exemption. Okay, but we still have to have a duties test that's satisfied. The outside salesperson, and this is an exemption that's recognized under the FLSA and all of the states we're talking about today, New York, Connecticut, Massachusetts. The primary duty has to be making sales or securing orders or contracts for services or the use of facilities for which a customer or client is paying. Okay? In order to be considered an outside sales employee, who qualifies for this exemption, it has to be an employee who's regularly or customarily engaged away from the employer's place of business.
And that's a really important point. When I've had the Department of Labor audit clients and or make charges against clients, it's often on this prong that the outside salesperson is not really outside. So if this person is supposedly outside, but they're in the office of the location where they're supposed to be doing their sales, and they're making most of their sales by calling people on the telephone from their office, they will not qualify. That really, truly is supposed to be outside. If they have an office, which is they're not really supposed to, or at least they shouldn't be there.
Okay. So what kind of work are we talking about for these outside sales employees? What kind of work is exempt? Well, obviously, work that would be performed in conjunction with their outside sales or solicitations would be covered. So, writing sales reports, the time spent doing this work would certainly be considered exempt. Updating or revising the employee's sales or display catalog, planning itineraries, attending sales conferences. Work that furthers the sales of other employees is not considered exempt work, however. So it has to be, basically it has to be work that benefits that particular employee, and it can include these incidental activities that are in conjunction with that employee's own outside sales. So, lucky you, we've come to the end. Does anyone have any questions? The answer to that is yes. Will we be able to get these slides when the webinar is finished? Yes. On Monday, I believe Michelle Ketchum is going to be sending an email to everyone who participated in today's webinar with copies of the slides. Yes. What is the normal work week? Is it 40 hours? Yes, 40 hours is set as the normal work week for most industries, and anything over 40 hours is considered overtime hours.
Right. So the 40 hours. So when you're talking about a non-exempt employee,
right?
Non-exempt. That's somebody who has to be paid overtime, somebody who does not qualify for one of these exemptions. A non-exempt employee under the Fair Labor Standards Act and state law has to be paid time and a half of their regular rate, which is another calculation depending on what their rate is, overtime. So that applies to non-exempt. Okay. That's right.
There is no really set work week for exempt employees, although you can require an exempt employee to be in the office during business hours if that's the type of job they have. But beyond that, there really is no work week. Yeah.
So the new rule changed only the salary basis. So the new rule that's going into effect is just has to do with the salary basis. So if if you believe that your employees were under some other exemption, that applies in Connecticut or wherever you are, the issue there is look to your state law. If you're not in Connecticut, I don't know which state this is, but look to your state law to make sure it's still a good exemption. But the federal change is only with regard to the salary basis test. Teaching, I see here a question about a teacher contract. Teachers are often paid over 12 months for a 10-month teaching position. That's very common.
And there's nothing wrong with that. You know, one of the things I think that we thought we might see at some point, and Trish, I don't know what you think, I don't know that we're going to see this, is a modification to these duties tests. Just like we've seen a modification in the salary threshold. Do you see a change any time in the near future on the actual duties test so that it becomes easier to apply?
No, because it took them about 5 years to get the salary basis test. I don't think they care. I don't think they want to go through this again.
I think they said, you know what? We'll stick with it. Let them pay these people more money, and then we're good.
Right.
We're all good.
I truly think so. It's such a long process.
It is.
All right. So, we just wanted to prove to you today that we can have fun with the FLSA. I hope you all learned something, and you'll get the slides. Thanks for participating.
Thank you, and have a wonderful weekend.
Have a great weekend.
Bye-bye.